The ruling delivered by the three-judge bench, Judge Ogola, Mugambi, and Mrima, is a sound ruling, a sound decision.
Is it?
It has upheld the impeachment of Rigathi Gachagua.
Was he impeached?
It has also confirmed that the appointment of Professor Kindiki as Deputy President was done in accordance with the law. There was no need to have the input of IBC. And the ruling is quite substantive. It has dealt with the issue.
Was there any voting? Was there any voting in the National Assembly?
Your matter has not been argued. Wait.
Was there any voting? There was no voting.
In the National Assembly, the court has held that the National Assembly process of confirmation was a process that had no constitutional foundation, and therefore the court has found that the National Assembly, though it confirmed Kindiki as the Deputy President, needed not to go through the process. But number three, and this is important, under Article 157 of the Constitution, an impeachment is final. It is a final process. And that is why, though the court found that Senate ought to have accorded Rigathi Gachagua an adjournment, it has not faulted the impeachment. The impeachment is final. It has only awarded damages of 50 million to be paid to Rigathi Gachagua for not having been heard on an adjournment because Senate rejected the adjournment. That is the only positive finding. But I'll tell you this, that since the petitioners will file an appeal, there will be many appeals, Senate and other parties will file a cross appeal because you can only file one appeal. Once an appeal is filed, then you file a cross appeal. So I think the court has gone through the issues decisively. It has dealt with constitutional issues, the thresholds. It has found that the National Assembly went through the process of public participation properly, and there was sufficient public participation. The National Assembly presented a formal motion, went through public participation, presented a proper case before Senate, and Senate voted properly for the decision that eventually led to the impeachment. I think this is a good decision.
You're calling it a good decision, yet, sorry, Tom.
It's a good decision on many fronts, yes.
Yet the court has, and this seems to be the main pain points for the petitioners, the court has acknowledged an infringement of a right. And it has gone ahead, yes, to offer a reprieve in terms of 50 million shillings, but many would say an infringement of a right does not have, should not have a reprieve.
No, the court has made a finding on the exercise of discretion by Senate. It has found that the Senate ought to have allowed Rigathi Gachagua more time to present his case. Remember, the National Assembly had presented its case and the witnesses had been cross-examined by Senate. So the court has simply said you should have allowed Rigathi Gachagua equality of arms. It does not take away the vote. It does not take away the 11 grounds, out of which 6 failed but 5 succeeded. Remember, in Senate, 1 ground is sufficient to impeach any person during an impeachment proceeding. And that's why the long analysis on impeachment, the provisions of the Constitution, Article 180, and how governors are impeached, the court was able to go through all that and analyze. This is a balancing act. In the end, the court balanced by paying for the injustice that it felt had been carried out by the improper exercise of discretion by Senate. But does not in any way mean that Senate acted illegally. It merely acted at the time because it did not have material before it, the material that showed where Rigathi Gachagua was at the time. But it has said, because of that, the possibility that it should have adjourned, we will give damages. But that does not affect the impeachment. Gachagua stands impeached. That's the position.
A quick one, Wakili. Are you saying that the process that you took Gachagua through was free and fair, yet the court actually said that he was infringed?
The process that was followed by the National Assembly, public participation, was found to have been proper. That's number one. Number two, Senate needed not to undertake public participation. Number three, the court only faulted Senate for not having allowed the adjournment to the next Monday or Tuesday because there was some time. But has said that because Senate exercise his discretion through a vote of senators, that decision or that final decision or outcome cannot be faulted.
What are your chances at the Court of Appeal because they filed an appeal?
We win our cases. I can assure you that the political question doctrine will be dealt with at that point.
All right.
The independence of Senate will be dealt with at that point. And I'm sure that the Court of Appeal will not arrive at a different decision on the finality of the impeachment under Article 157 of the Constitution. Thank you.
Thank you.
Okay. Thank you so much. That is Milimani Law Court, and of course, it is a session that has seen the battle of those lawyers here trying to find out the reason, or rather the ruling that has been made here, trying just to bring to light what has been decided here at Milimani. President Rigathi Geoffrey Gachagua has been awarded a 50 million because he was not given a fair chance to be to be tried at the Senate, or rather to be listened to. But the judges still upheld that, he still stands impeached. And of course, they still say that the process of impeachment still stands, but the aspect of him not being given a chance of being heard is where they had questions about it. And of course, moving on to some of the issues, Ian Keitani, that has been discussed here, it is very clear that the National Assembly has been given a leeway because the judges clearly said that the National Assembly didn't and it did his public participation to the allowed standards. And of course, that tells you that, and of course they're saying because the offices across the country were open and ready to receive those submissions, it is very clear an indication that the National Assembly tried to do all this. And of course, we've got to be talking to other lawyers who will be joining us in a few, but everyone here is exhausted, and the lawyers are actually feeling exhausted because they've been sitting here all the way from 11 a.m. up to this late in the night. And of course, something else that we need also to note, it is very simple that the Deputy President Kithure Kindiki, who is in office according to the laws and according to the legality of this. We're going to be speaking to other lawyers here just to tell us what is your name and what do you think about the ruling today.
Yes, I'm Phyllis Wangui Kamau, counsel, and I was appearing for the 43rd petitioner. And what I have submitted at the end and what I have said is that this is a constitutional absurdity. And the court has even mentioned that because there is no constitutional, there's no any article of the Constitution that's more superior than the other. And the court has clearly stated that the right to fair hearing for His Excellency Rigathi Gachagua was infringed. That's a constitutional provision. And therefore, it carries the same weight as Article 157 or 145 that the Senate used to impeach him. In that sense, and in all cases where a Bill of Rights or a constitutional provision has been infringed, what usually happens is a clear declaration that then that process was illegal or unconstitutional. And then what follows after that is orders to that effect. Now, the court has held itself back from declaring the impeachment of Rigathi Gachagua illegal and unconstitutional, but then granted him a small right to pay him. And I can give you an example. When you come on an employment case matter, and you then say that your employer did not follow the process or did not have sufficient reasons, under the Employment Act, which is just a statutory act, to have terminated your employment, before the court grants you the reliefs, they must declare that that process was either illegal or unfair. We expected the court to clearly pronounce itself to declare the process unconstitutional and illegal for the violation of His Excellency Rigathi's rights to fair trial.
What would have happened if you say it would have declared that it was illegal for his, and now would we have a situation where we're having two deputy presidents because they also did that out of public interest?
You see, even in employment matters, an order to reinstate is never automatically given. because the court can assess the requisite orders and grant you the reliefs that are fair in the circumstances. But the fact that it was illegal on a ground cannot be taken away from you. Okay, the reliefs can vary, and we do appreciate, and in fact, His Excellency Gachagua had actually withdrawn the prayer to be reinstated because it's overtaken by events.
Now, with that withdrawal, what were you expecting?
We wanted it to be declared illegal because then that removes the constitutional burden that is on His Excellency Rigathi Gachagua, that he is an impeached leader under Article 3 or Article 2 of the Constitution, that then makes it impossible for him to vie for an elective seat. We need that pronouncement because the process did not follow the Constitution, therefore it is illegal. And in that regard, then it allows him. You cannot say, and we always say in the law, and you heard the court say, justice must not only be done, it must be seen to be done. Both the process, the substance of the law must be taken into account. You cannot withdraw someone's right just because another person's right would be interfered. Granted that perhaps the order to reinstate was already overtaken by events, and we did appreciate on our side. But the declaration for illegality and unconstitutionalism should have been made. And that's why in my final submissions I said this is putting us into a constitutional absurdity of the highest order.
Okay, thank you so much. Maybe my last question is, what are your expectations as you have promised to do an appeal? And of course, you've already filed that appeal, or rather you're in the process of filing that appeal. What are your expectations at the Court of Appeal?
So our expectation is to go through the motion. I think it is, at the end of the day, the High Court has pronounced itself. And therefore, we have to respect the judgment of the court. And the best we can do is ask for that judgment and go into appeal. And we do expect that we will argue our case strongly as it is required. Remember, one of the things the court has said is that it has tried to distinguish the impeachment of a governor and the impeachment of a deputy president. Because one of the cases they are relying on is Sonko versus others, which went all the way to the Supreme Court, but it is in regards to impeachment of a governor whose threshold is lower than the impeachment of a president. And therefore, we will go to the Court of Appeal, and if the Court of Appeal doesn't rule in our favor, we will still go to the Supreme Court, because one of the decisions we must completely distinguish is decisions such as Sonko, and set a clear precedent on the threshold, standard, and constitutional requirements of impeachment of the office of the president or the deputy president.
Thank you so much. It is amazing to have a conversation with Wakili here. I'm going to be joined with another one here who can just give us your name and briefly tell us what were your expectations and if they were met, and what do you take from the ruling of today?
Thank you. My name is Dr. Peter Mbaye. I'm the Secretary for Planning and Economic Affairs at the DCP party. We have been here all those hours. I want to say from the onset that we respect the court ruling because that's why we have been here, but we don't agree with it. One is that you cannot say that the Honorable Rigathi Gachagua's rights were violated in that he was not given a fair hearing, and then you don't give a remedy, you don't give a relief. I want to say that the 50 million shillings is an insult, because we never came here for the money. We came here so that, we respect the law, whatever is contained in our laws and regulations and the Constitution. So you can't say that the laws, and if one part of the law is violated in the Constitution, it should carry equal weight in terms of relief. Okay? So let me say this. The Honorable Rigathi Gachagua remains our presidential candidate in DCP, who we are going to endorse in our NDC, and give him up to the other principals in the united opposition, and he stands an equal chance to vie for the presidency of this land.
But that only comes if the appeal, or rather after you get a success at the appeal. If not, that means it's not going to be on the ballot.
Listen, we are going to go on with the Court of Appeal. And if whatever happens faster, if the elections come before, we'll be in the court until Supreme Court. So we don't manage the diary of the court. If they want to fast track it, fine. We are going to pursue this matter, because let me tell you, the impeachment, the hurried impeachment happened in the public. Everybody could see, right? The public hearings here have been public in media, so everybody could follow. Every other Kenyan have an opinion about what should have happened, right? So they have an idea. If you don't have to be a lawyer. So what we are saying here is that there are some critical rights of the Honorable Rigathi Gachagua that were not respected. We simply want this, kindly, the court to come and say, agree with us that yes, there were some issues that were infringed upon, and give a remedy. You cannot come and say, well, some rights were infringed, but then you run away and give 50 million. We are not here for the money. By the way, the 50 million shillings is an insult.
Can we say you are here just to get on the ticket?
I mean, it's very simple. We are saying we are going to get the Honorable Gachagua is our presidential candidate in DCP. And then we are going to give him over, among other principles, and he stands an equal chance to be nominated to be the president of this republic. These issues of the court do not stop us, so long as we have not exhausted their peace up to the highest line.
Thank you so much, Jesse Rogers. This is what is happening here. And of course, what we're going to wait is see how the battle is going to turn around in the Court of Appeal. Of course, the respondents are saying they are hopeful they'll win. And of course, the petitioners as well are saying they're hopeful they're going to win this. So we're just waiting to see. And of course, we're going to be getting other reactions. We're going to just tell our listeners and our viewers to keep tuned, because we shall be giving you more details in our subsequent bulletins as we begin even tomorrow, and having more of these interviews. I bring it back to you, Jesse Rogers, live from Milimani. My name is Haman Kamariki.
Well, thanks, Haman Kamariki, for the tete-a-tete.